Imagine this scenario. You're within 100 miles of the US border and a border patrol agent pulls you to one side and demands to search you, your vehicle, your possessions including your electronic devices like your phone and your laptop. No reason is given and they claim that you do not have the legal right to stop them. So now you have a choice to comply or to resist. You're about to see the actual footage of what happens to someone when they attempt to defend the Fourth Amendment right. Welcome to RINF News, I'm Mick Meaney, and in this report we're going to examine reports from America that have long indicated that border agents have been using questionable stop and search procedures on travellers who enter or leave the country, and also on those within a 100-mile radius of the border, potentially affecting 190 million Americans who fall within that radius. And the directive does not define who a traveller is. Now you're about to watch a video of a pastor, Stephen Anderson, who refused to be searched and the hideous treatment he received, being beaten and tased as a result. I must warn you, the following scenes are disturbing.
Well, let me ask this. Are you placing me under arrest?
You are under arrest.
And what crime am I being charged with?
Hey, these guys are telling me that a canine alerted to your vehicle for the presence.
And I've asked repeatedly for that dog to be brought back out because I say that it didn't happen. And they are refusing to get the dog back out because they know that they're not telling the truth.
You can do one.
Because I wouldn't answer their questions, they came up with that.
Or I'm going to take you out of the car.
Well, let me ask this. When you place someone under arrest, don't you have to put them under arrest for something specific?
Okay, I'm a police officer. I'm ordering you out of the car.
Will you answer my question, police officer?
Yes, I'm a police
What
officer.
are you placing me under arrest for?
You're fair to obey me right now.
So I have to obey you by law?
Yes, you do.
Even when you're stopping me without cause?
Hey, close your eyes. Close your eyes.
I can't do anything from there.
Hit low right here, you'll be fine.
Okay, yeah.
Ready?
Yeah.
This is it. Fall.
As we can clearly see, the treatment of citizens can be horrific now. Yes, security must be paramount, but for some time now, many civil liberty groups have rightly questioned the seemingly irrational searching of citizens in this manner. At the moment, border agents do not need a warrant, they do not need to have reasonable suspicion, and they essentially just need to have a hunch. Now, as you can imagine, civil liberties groups have challenged this under the Fourth Amendment, which is really designed to protect civil rights. Here's a quick reminder of the Fourth Amendment. Now, as you can clearly see, it states the right of the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, for those of you who aren't aware of this directive, the ramifications are probably best explained by Harley Geiger from the Center for Democracy and Technology, who spoke to Russia Today. Now, he mainly focuses on the warrantless searching of electronic devices.
Americans have a diminished expectation of privacy at the border. However, When they search laptops or PDAs or cell phones, it actually reveals an enormous amount of information about ourselves, our personal lives, our financial records, our relationships, medical history, etc. And these are the things that the Fourth Amendment was designed to protect, and now it's being subverted in the name of national security. So there's an argument to be made both ways.
And I know that you guys recently uncovered new rules regarding these searches, and maybe the policy has changed a little bit. Can you talk a little bit about that?
Well, there was FOIA litigation, Freedom of Information Act litigation, through EFF, and they had uncovered rules that had been changed in 2007, actually. So it's not announced under the Obama administration that these are new. It was just uncovered that this was the policy. But the policy had changed in 2007. Now there is no suspicion required whatsoever for federal agents at the border to search your laptops or your electronic devices and to copy the material that is on them. Previously, prior to 2007 and since 1986, they required reasonable suspicion to detain a laptop or an electronic device and probable cause to seize or copy it. Now those protections are gone, except they still need probable cause to seize it, and they need reasonable suspicion to share it with another federal agency like the NSA or the CIA, which they will do if they need to decrypt it or they need help understanding the contents.
And what exactly are they looking for? I mean, can they look through these laptops and get your email and look through your Facebook accounts or something like that? I mean, what are they trying to prevent by doing these searches?
They can get anything that is on those electronic devices. Now, electronic devices is very broad. It includes MP3 players. So they can look through the music files on your MP3 player if they want to. Yes, they can look through your Facebook profile. They can look through any file that is on those devices. What they're looking for, generally, they're looking for anything. Anything that indicates that a crime has been committed. More specifically, they're looking for child pornography. They're looking for evidence that the person trying to cross the border is not who he or she says that they are, that he or she might be a terrorist, or that he or she is lying about their immigration status. So it's a very, very broad search.
Okay, now that you've been brought up to speed, let's fast forward to February of 2013. The Office for Civil Rights and Civil Liberties at the Department of Homeland Security released an executive summary of its findings to justify the warrantless searches of phones and laptops. However, it refused to release the details of its analysis. So essentially, the US government gets accused of acting outside the law, so the government conducts a review of itself and, surprise, surprise, decides that it has done nothing wrong. Well, what else is new? Okay, well, last week, in response to a Freedom of Information Act request filed by the American Civil Liberties Union, the Department of Homeland Security finally released its complete December 2011 Civil Rights, Civil Liberties Impact Assessment. So let's take a closer look at how the Department of Homeland Security attempts to defend itself. The assessment first counters by noting the issue is an important one, even though it affects only a very small proportion of many millions of travellers who enter the United States each month. Now, according to the government's own figures, there were 302 travellers subject to electronic device searches in 2009 and 383 in 2010. Now, still, that raises the question, what is the government's constitutionally based reason for such searches? Now, frankly, we don't know, and a lot of what they have provided is redacted. On page 18 of the 52-page document, under the section entitled First Amendment, several paragraphs have been completely blacked out. The DHS also says that it definitely can't change its policies to be suspicion-based, as it would be operationally harmful, but it fails to say why. Now, not surprisingly, the ACLU takes issue with this line of reasoning in a blog post they wrote. To be sure, rummaging around through people's personal papers may well turn up the occasional bad guy, but that is not the only consideration. No doubt law enforcement agents would also find it useful to walk into people's homes at will, but we don't allow them to do so because that would intrude on our reasonable expectation of privacy in our homes. And just as we reasonably expect privacy in our homes, so too do we expect that border agents will not base their decisions to search through our electronic information on a whim or a hunch. Put another way, requiring law enforcement agents to possess subjective reasons for a search is a feature of our constitutional framework and not a bug. So what we essentially have here is the warrantless searching for no good reason other than because they feel like it. That's a completely irrational and illogical stance that violates the civil liberties of hundreds of people each year. Well, I'm almost out of time for today. For more news that you're not supposed to know, visit RINF.com. Thanks for watching. I'm Mick Meaney signing off for RINF Alternative News.